On Thursday evening, the Constitutional Court, in a majority decision, ruled that the lifting of the presidential age limit was constitutional. The ruling will allow the incumbent Yoweri Museveni, who is 73, to run again in 2021 if the appeal is allowed and not overturned by the Supreme Court, the highest appellate court. The decision extending the term of office for lawmakers from 5 years to 7 years was annulled by the Constitutional Court.
I would therefore strike out sections 2, 5, 6, 8, 9 and 10 of the Constitutional Amendment Act 2018, which provide for the extension of the tenure of Parliament and local government councils by 2 years.
I find that the consolidated petitions have succeeded on the issue of seeking declarations to be issued that the extension of the term of Parliament and local government council from 5 to 7 years, and also that the reinstatement of the presidential term limits are unconstitutional.
But to the extent that the MPs, in what appears to have been a trade-off between President Museveni, they clearly were fooled that in exchange for extending term limits, they would therefore get an extension of their term. They clearly missed the ball on it, and in that to that extent, they have lost.
Justice Kenneth Kakuru, however, ruled that the entire Constitutional Amendment Act was null and void.
The entire Constitutional Amendment Act of Act 1 of 2018 is unconstitutional and therefore null and void.
But beyond the spectacle that lasted about 12 hours and was televised, did courts of law insulate themselves from the politics of the day?
My understanding is that the nature of the judicial function, especially at the very highest levels, the Constitutional Court and the Supreme Court, means that courts may never really quite be insulated from politics. The courts must not shy away from determining legal questions that have political effects. And I think that's a very important distinction that can be made. In the International Court of Justice, for instance, the court has determined in the hostages case and similar cases that the court can and should make legal determinations, possibly excise those legal determinations from political questions, and then proceed to make determinations on those legal questions, even if those determinations have political effects. And I think that is an approach the court in Uganda should pursue.
It is clear that the court was never going to upset President Museveni and his wishes. Every pundit, whether professional or non-professional, predicted this decision. And when you have a court that's predictable, you can't help but think that the interest of the president was paramount and they had to find a way and all means to preserve it. The interests of the MPs were the lesser interest and therefore could be jettisoned by all means of legal arguments. And therefore I think that the court may have had the wider interest of the president at the back of their minds.
French philosopher Montesquieu developed the doctrine of separation of power, where the political authority of the state was granted to the three independent arms, the executive, judiciary, and parliament. However, in his book, When Courts Do Politics, legal scholar Professor Joe Oloka Onyango postulates that the separation of government power that operates today is a far cry from that which was articulated by Montesquieu, a formulation that could be said to belong to the realm of mythology. It is not as rigid as it was initially designed to be, and each branch of government makes political choices and decisions. As questions remain abound in regard to the independence of Uganda's judiciary, the latest ruling by the Constitutional Court will likely set off a fresh contestation of whether courts are hostage to politics.
That our courts are not yet assertive and courageous enough to rule against especially the incumbent, because the manner in which the age limit provision was deleted from the Constitution was very, very controversial. It was littered with all sorts of dubious practices. And I think that those processes were illegal in Parliament. Justice Kenneth Kakuru did address himself to that. I think the other judges should have followed suit.
To allow for life presidency is to subject us to a one-man rule. That is the element of being monarchical. that now Ugandans are forced to subject themselves to the leadership of a single person until death calls them. That is what monarchs do, queens and kings, until God calls them. And ironically, we know that in the succession plan, some of these families have carefully staged themselves. You will find a president, a minister, all these presidential advisors in the military. They have strategically positioned themselves for a takeover.
This is often through the political question doctrine, which essentially prevents a court of law from determining issues that are viewed as political within the purview of the executive branch of government. Some critics argue that beyond the hallowed grounds of these courtrooms, judges are mere mortals who are inclined to make decisions that are based on their conservative values, morals, and political inclination.
For instance, we could also look at what Kenya is doing. The aspect of public vetting is very, very important of judges. I think that can mitigate the various political interests vis-a-vis what's legal, vis-a-vis the allegation of cadre judges and that kind of stuff.
The role then is to interpret texts and make legal decisions, but to make difficult choices on questions of morals and politics.
Every constitutional decision is a political decision. Just that it is a considered decision that is made amidst a number of principles, so that the interests of the country, right, are taken into account. And that circumstance is not unique to Uganda.
Oloka Onyango, quoting Professor John Griff in his classic text on judicial politics, The Politics of the Judiciary, states that judges are part of the machinery of authority within the state and as such cannot avoid the making of political decisions. What is important is to know the basis on which these decisions are made. Judges are, according to the theory of attitudinalism, simply politicians sitting behind a bench. In Uganda's context, some observers opine that an imperial presidency gives the incumbent unfettered powers to appoint judges. This allows the intrusion of politics into the judicial appointment process.
And so some of the judges are known to have been involved in the current government as ministers and so on and so forth. So their opinions very much were influenced in some ways by their political history and by their being, what are referred to as cadre judges.
But what essentially should be the discussion for me is not about the appointment of the judges, but rather about the power of the president in the constitution. I think the power is vast, and that he has no control and check over him. The judiciary has proved unable to do so, and so has Parliament. So there has to be a proper evaluation of how we deal with an imperial presidency that President Museveni has become.
Why are they being emotional? I know what they are being emotional because they are tired of seeing His Excellency President Museveni at the helm of this country. If you're tired of that, go to the Constitution. Like I was saying, the Constitution allows you to go to the vote and ballot and vote him out of office. Simple. That's how democracy works.
The Constitutional Court, just like other courts, is composed of judges who are nominated by the Judicial Service Commission. The powers are also vested with the President to select those he deems fit. It is this list that is sent to the Appointments Committee, which is largely rubber-stamped by the President's choices. However, there is a concern with the neutrality and the impartiality of how the justices can determine a fair verdict after they have been chosen by the President.
In order to retain its sanctity, the courts of law are supposed to keep a safe distance from the political theatre. Under Article 137, any question hinging upon the interpretation of the Constitution shall be determined by the Court of Appeal, sitting as a constitutional court. It is what then is determined by the bounds of what is termed as judicial activism or judicial restraint.
Judicial activism is where, say, judges' individual views and political persuasions are taken into account to make judicial decisions. And judicial restraint is the reverse of that, where the judge must stick to the law and the Constitution and whatever is.
During Thursday's ruling, the question over the role of security forces at Parliament in the fracas that led to the violent ejection from the House of Opposition lawmakers remains a contested issue.
The overwhelming number of members of Parliament held and carried out their meetings of consultation of the people uninterrupted. In conclusion, the answer to this issue is that the Constitution Amendment Act number 1 of 2018 was not enacted as a result of violence having been exerted upon the honorable members of Parliament.
Storming of Parliament by the Special Forces Command, SFC, was something that the judges should have condemned, because there is no way you can have Parliament conducting its business while the military and the security agencies are involved as well. We have a problem here where our politics are very much driven by militarism, and the courts this time round should have spoken out strongly against having security agencies and especially the military involved in processes that are entirely political.
Now, to justify the intervention of the military to disrupt what was a lawful filibustering process, and for that to be endorsed by the court as necessary, was tragic. Because what happened when the law was being passed was even worse than what happened when the pigeonhole constitution was being handed down to Parliament by the Milton Obote government in 1964.
So fortunate that it's extremely important for civilian matters be dealt with by civilians. The Parliament has the security provided in Parliament, which can and should have dealt with that matter. There are other mechanisms available to the Speaker, such as adjourning the session, which can and should have been used.
In their ruling, some of the justices ruled that the deployment of security forces was necessitated by a security emergency. There is fear that this could give the army and other forces a pretext to target the regime opponents, a character of Uganda's turbulent history.
All in the heart.
However, Oscar Kihika, who is the legal director of the ruling party, says there is often a lot of public sentiment on outcomes of court decisions, but the technical abilities of judges is what distinguishes these sentiments from the outcome.
And the judges were at pains to go back into the Odoki Commission, okay, which reflected and they quoted, I think, that 800-page report, where they quoted that report saying that the majority of the people, when it came to the issue of the age of the president, were of the view that the limit, the lower limit for a person to qualify to become president was the age of 40, and there was no upper limit imposed. Okay? It was the Constituent Assembly that then decided to introduce the upper limit and then reduce the lower limit.
The ruling also introduced the basic structure doctrine into Uganda's legal discourse for the first time. This doctrine presupposes that the Constitution has certain basic features that cannot be altered or destroyed through amendments by the Parliament. Whereas some justices provided a narrow interpretation of the doctrine, Justice Kakuru seemed to give a wider context in his ruling.
Well, I think in Uganda, Uganda has now become listed amongst those countries that has partially adopted this principle, and I think this decision can be looked to or referred to when other countries are considering applying it.
But I think what the judges missed is the understanding that when a constitution is easily amended and changed at the whims and aspirations of individuals, in this case the president, you are undermining constitutionalism, which is really what the basic structure idea touches on. When a constitution can easily be amended to fit the
basic structure doctrine of essentially provides that certain provisions of the Constitution are so fundamental that if you amend it, you have essentially amended the entire Constitution. You have removed the very core pillar of the Constitution. It's like three stones under a pot. If you remove one stone, the pot falls. So the basic structure doctrine provides that certain provisions of the Constitution is beyond the amendment powers of MPs. And if MPs amend it, they essentially overthrow or amend the entire Constitution. I think that the concept is a judge-made concept. It is not a concept written in law. It's a concept derived from common law, beginning from a Supreme Court decision in India. I think the way that that doctrine is applied perhaps could have gone a lot further. Because if the MPs applied the basic, if the court applied the basic structured doctrine as argued by the lawyers, I think the entire amendment would have collapsed.
Legal scholar Dr. Businja Kabumba, however, says that the Supreme Court at an appropriate time will need to offer a much harmonized position on this doctrine.
Well, for instance, once one has accepted that there are certain basic fundamental pillars of the Constitution which are unamendable, that the parliamentary power to amend the Constitution is restrained, the follow-up question then becomes, what parts of the Constitution are those that qualify to be either unamendable, or what parts of those of the Constitution qualify to be understood as the fundamental pillars? Now, the responses in that regard were unconvincing, insofar as if one says Article 1, sovereignty of people is a basic, is a fundamental pillar, and then somehow one considers that the limits on the presidential on the presidential terms, not just terms, but limits on presidency, how far one can stay in that seat, that is not fundamental. The obvious question then becomes, where do you draw the line? What are the parameters for the considerations? Are we going to look at Article 260, which is itself problematic in that sense? For me, there are deep questions that have to be answered.
Even Western democracies like the United States continue to grapple with the question of politics infringing upon the space of courts of law. Uganda can make strides in protecting the impartiality of the judiciary by introducing a raft of changes in the way judicial officers are vetted before they are appointed. Andrew Nitwe, NTV, Kampala.